Welcome. I'm attorney Carlos Colombo from Colombo and Hurd. And today we're going to cover an interesting topic. We have a lot of folks around the world that have requested that we touch on the first 100 and so days of the new Trump administration and how that may affect immigration cases, especially high skilled immigration for professionals. So we're going to touch on three main topics today. We're here live with you. We already have a bunch of folks that have joined from around the world. We have Liana from Latvia. Let's see, we have Antonio in Spain. Antonio, I will be in Spain soon. So um, we also have folks from India, Parveen in India, uh, from Nepal, Nirmal. Welcome, everyone. We have people in Canada and throughout the world that are interested in knowing what the Trump administration is focusing on. So today I will touch on three main topics. Number one, some of the key executive orders that the Trump administration has issued in those first 3 months or so of this administration, and how that may affect your immigration case or the future of a case if you're planning on doing some of those filings. Number two, some of the recent trends we've seen with the new administration for EB-2 national interest waiver cases, EB-1A for extraordinary ability, and O-1 temporary visas for those high-skilled immigrants. And finally, we'll touch upon some of the consular posts around the world and what we're seeing with immigrant visa issuance under the new administration with Marco Rubio's new Department of State. We'll, of course, do some questions and answers at the end of the live today. I'll give you guys all a chance to ask those questions. It's usually impossible to get to everyone, but I will try to do as many questions as I can from you all. But let's leave those towards the end. So let's get right into it. Let's talk about some of the executive orders. And let me start a little bit with a little bit of context, because obviously the President Trump has come into office and has issued, I think, the most executive orders of any president in history that may affect different parts of the United States and its foreign policies. But I want to focus on what those executive orders could mean for you if you're thinking of filing a case or if you have perhaps a case pending. Um, so let's first look at some of the executive orders that they have issued that could affect either positively or negatively your case. So first, executive order on artificial intelligence dominance. That is an interesting executive order because it emphasizes that the Trump administration and the U.S. want to be the leaders in artificial intelligence around the world. And to do so, they have asked that a comprehensive AI action plan be implemented in those 180 days from the date of the issuance of that order. So obviously, AI has been a hot topic not only in the U.S. but around the world. So folks in AI fields and technology that could benefit that action plan towards AI would obviously be a national priority that would help endeavors that are focusing on EB-2 NIW, folks that perhaps are going to be working more temporarily on O-1 visas. So obviously, artificial intelligence continues to be a very hot topic for the Trump administration, and they want to dominate, as the executive order words it, that field. So that's one executive order we have seen that is positive for technology applicants, especially self-petitioners for some of these applications. Executive order unleashing American energy. That is an executive order that was issued, I think, in January of 2025. And it promotes energy exploration and production on federal lands and waters. It aims to increase domestic oil and gas production. So, obviously, the priorities of the Trump administration are going to be different than under the Biden administration. And they're putting a little bit less emphasis on wind and renewable energy, although those still could unleash some American energy capabilities. But I think the focus has been on oil and gas, especially in these first 100 days of the administration. So we have a lot of folks from Venezuela, from Nigeria, from countries that have quite a bit of Canada expertise in oil and gas, um, and we have seen an interest from this administration in continued development to basically what the Trump administration is trying to do is trying to rely less on foreign sources of oil and gas and more domestic production. So that is something we have seen as a positive for our clients that have experience in the oil and gas industries. Uh, and then, obviously, number three is going to be on manufacturing with the recent chaos, I would word it, with the tariffs that have been announced in the last few days. Obviously, this administration is trying to place a significant emphasis on manufacturing in the United States and, again, less reliance on foreign sources of manufacturing. Um, whether that is something that is a good idea or not, I'm not going to get into that today because that doesn't affect your immigration case. What it can do is it can help if you are high skilled and you are bringing your talent to the United States. An interesting statistic that we've seen, and this was a study that was done pre-Trump. It was done, I believe, in 2024. Deloitte and the Manufacturing Institute in the United States did a study, and it showed that there is a significant shortage of skilled workers in manufacturing in the U.S., which is not surprising, right? Because the U.S. has not focused on internal manufacturing in the last many decades. So it's not a surprise that we have a shortage of skilled, and there's both that are needed for manufacturing. You need both skilled and unskilled workers. But on the skill side, listen to this statistic because I think it is staggering. And I think it is something that the Trump administration will have to eventually recognize the need of foreign talent coming to the United States if it truly wants to energize the manufacturing industry domestically in the US. This Deloitte study predicts that as many as almost 4 million new workers would be needed by 2033, potentially leaving almost 2 million positions unfilled. So almost half of those estimated jobs that will be needed in manufacturing that are high skilled jobs. We're not talking about unskilled. We're talking about high skilled would be left unfilled because there are simply not enough skilled workers in manufacturing in the United States. Now, that study was done before any of these tariffs and any of these new measures were announced. So my guess would be that if the Trump administration is moving to dramatically increase manufacturing in the U.S., these numbers will go up dramatically. That would be my guess based on this study. If 4 million jobs, high skill, would be needed prior to the announcement of these global trade measures that the Trump administration has announced recently, then the number of skilled jobs in manufacturing will need to increase if America is going to compete at the international level. So Very, very interesting statistics. It is not surprising to us. We do this every day where we represent clients that are in the national interest in EB-2 national interest cases that have high level of talent for EB-1A cases or your O1 case. Um, they are clients that are bringing a significant benefit to the United States. And we know that there's shortages of high skilled workers throughout many industries, manufacturing being obviously one of them. Um, but the other thing we're seeing is that in STEM fields, we continue to see favorable adjudications and the need for high skilled workers. Medicine being one of the critical fields where there are shortages of talent in the medical fields. Obviously, in science and technology, engineering, those are fields that will continue to be in high demand. And again, this is especially true with the recent announcements. And um, if you look at the other side of the coin, sure, there are some concerning executive orders that have been issued, um, and there are some issues where I would say some chaos has been created by the Trump administration. I mean, the tariffs being obviously one of them that has uh, resulted in markets going down and sort of the situation around the globe with trade being sort of flipped on its head. And I think that what we always need to keep in mind is where there are these chaotic situations, there's always opportunities also. So, chaos can sometimes bring opportunities, and we need to focus on what is favorable to you if you're looking to do an application to either move permanently or temporarily to the United States. Um, we have to look at those opportunities. And I think that those fields where you have energy, oil and gas, and let's not forget mining. There's an executive order on increasing production nationally in the United States of critical minerals. So that is also going to be important. Anything that could domestically benefit the United States is going to be a priority under the Trump administration. That doesn't mean that other fields are not going to be winning cases. It's just that these are the priorities that they have highlighted in their first 100 days. And that's sort of a summary of what we're seeing with those policies. Now, there are some policies that you need to keep in mind. Um, More vetting is obviously going to become an increasing concern for certain clients because this administration has been very clear that they want to make sure that every applicant is vetted and that your application is completed accurately. And to ensure the processing of those applications, they have warned. I've seen several warnings recently on the USCIS website, the U.S. immigration website, quoting, the wrong help can hurt you. And that is true because you need a licensed attorney in the United States to represent you in your case. So be careful in making sure that you hire a law firm or an attorney that is licensed in the United States because USCIS is increasing its vetting of your application. So that is important. Also, be careful with social media posts. Be careful with comments that you're making on your phone, on WhatsApp, or on other platforms because they are being very, very detailed on that kind of information. So it's always good to keep those issues in mind. What they have emphasized is they want legal immigration. They want people to follow the law and follow the rules and not try to do things the wrong way. So that's where us as immigration attorneys with decades of experience can help you, making sure that you file an application that is well prepared and that it touches on the necessary requirements, and also making sure that you are not uh, filing an application that in any way could hurt you down the road. And that's sometimes the problem with folks that are either are doing it on their own or hire non-licensed attorneys or agencies that are not licensed to help you in the United States. So be careful with that, because we have seen the Trump administration wanting to be more stringent on the application filings. Now, what are the trends? That I think that's a good segue to some of the trends that we've seen with um, with applications, especially in the EB-2 NIW arena, EB-1As and O-1s. We have seen an increase in requests for evidence, or RFEs. That was expected, because we know that, again, this goes back to what I just discussed earlier, which is a little bit more vetting, being more careful with applications, but also because there's been a huge increase in the number of people that are interested in moving to the United States. And so, as more applications are filed, um, officers who have discretion in all these cases tend to be more careful, and immigration tends to issue more RFEs. Request for evidence doesn't mean that your case is going to be denied. It doesn't mean that you filed a case that is bad. It doesn't mean any of those things. It just means that the officer or immigration wants more evidence to approve your case. In many other instances, it's not because you didn't send enough information, it's because they're buying time, because they have a lot of cases that they need to adjudicate, and they're just issuing RFEs that are fairly standard. They sort of all look the same, um, because they just have a lot of work and they want to buy a little bit of time for themselves. So that's one reason. Some officers are more difficult than others, and are going to request more evidence no matter what you file initially. So it doesn't mean that your case is going to be denied. Okay. So if you get an RFE, don't panic. We here at Colombo and Heard, we have a team that is dedicated solely to helping you respond to the RFE, or us to respond to the RFE. There are experts specifically on handling RFEs for our clients. But this trend in more RFEs is across the board. So everybody's seeing that trend on especially EB2 NIWs, EB1As. RFEs have been part of EB1As for quite some time. So it's not unusual to see a slight increase in those in these first 100 days. On the other side of the coin, we've also seen increased approvals. So they've moved a little bit faster in the last few months compared to the last, I would say, 6 months of the Biden administration. There seemed to be a little bit of a lull, and not a lot of action. Um, so that's a positive outcome, and they have been approving cases in various different fields. So we have cases in STEM, obviously, like we talked about, in some of these fields that the Trump administration is happy to try to incentivize. But we've also seen the normal fields of that are less traditional fields of STEM, such as business administration. I even saw a few lawyers last week that were approved. So don't think that the only career that you can have in the U.S. With an EB2 NIW or an EB1A is in oil and gas and AI. Those are just some of the things that we've seen this administration incentivizing. Um, on the O1A, we've seen a big trend of folks wanting to do O1As because the O1A is temporary, but it gives you a faster way to move to the U.S. while maybe you're considering eventually a permanent solution, either an EB2 NIW or an EB1A. So O1As can be a good option, also because there's fairly flexible sponsorship opportunities. Um, uh, O1As are not a self-sponsor visa. You need an employer or an agent to sponsor you, but it's a lot more flexible than an H-1B or other types of sponsored non-immigrant visas. So O1As increase in interest and in filings. We've seen that not only in the first 100 days, but really in the last 2 years or so with O1As. In the EB-2 NIW world, I think one last point I would like to make is we've also seen an increase with RFEs and denials for employer NIWs. And what does employer NIW really mean? Well, because obviously the NIW, if we go back into the requirements, the NIW does not require that you have a company sponsor you. That's one of the big benefits of the NIW is that you do it on your own. You do not need a company sponsoring you. But because of that benefit and the fact that you don't have to go through the perm process, in the last few years, companies in the US have been essentially sponsoring employees through the NIW process to avoid the lengthy perm process and to avoid more time for those applications to be reviewed. And so they have been filing NIWs on behalf of some of their employees. And what we have seen in under the Trump administration is that they're questioning those applications because essentially what they're saying is you working for a US company is not in the national interest. Your work with that company in and of itself is not enough to win an NIW case. And I'm making it fairly simple in how I'm stating it. It's a little bit more complicated than that, but just for our audience to understand, that's essentially what they're saying. You need more than that. What is going to be the potential positive impact in the industry itself through the United States? It has to go a little bit beyond that, and I think that that's sometimes difficult for the attorney representing the company rather than representing you individually to try to go beyond just the company itself. And so we're seeing that at least we're hearing because we represent individuals like you. We don't focus on representing the big companies, but um, what we're seeing or hearing from colleagues as well is that there's a lot of questioning of those employer-based NIWs. Um, and also, perhaps USCIS is getting somewhat annoyed by the fact that the companies are using the NIW to sort of circumvent the perm process. On the other hand, they should be fixing the perm process so it doesn't take forever for the companies to do that. So it's a little bit of a game there that that may be happening, but that's the reality of where those employer based. So a lot of the times we get folks that maybe are their employer suggesting doing an NIW for them that maybe they rather do it on their own because they will control the process a lot better and they can make a more convincing national interest argument rather than simply through an employer. So that is a trend that we have been seeing and following in the last few months. All right. Final point, consular processing of immigrant visas. And this goes back a little bit to the vetting issue that I discussed earlier. The Department of State, the Department of State who handles embassies and consulates around the world, Marco Rubio being the new secretary of that department, they've said that they're going to make sure that folks that are entering the U.S. are not in any way a concern to the U.S. national security. So they are going to continue to increase vetting on individuals. So you need to make sure that you're prepared for those interviews. If you have an immigrant visa interview, um, you should be prepared by your team, by your legal team handling the case, and that's what we do here at Colombo and Heard. So we want you to be well prepared. It's impossible to predict what they may or may not ask you, but since we handle a lot of those cases on a daily basis, we prepare our clients for those interviews. Obviously, at the end of the day, um, you always have to be truthful in your applications. You have to be truthful to officers, um, but make sure that you're answering the questions correctly and you're prepared. Now, um, on the positive side of consular processing, we have seen a record number of immigrant visas. So essentially, the green cards, permanent residency applications approved in different consulates around the world. Bogota being one that we've seen a significant positive impact in the last 2 months. Um, but we are seeing it across the board where they're trying to move some of these cases along. Um, and we've had not only a record number of approvals in the last 2 months, but we also going forward, we're seeing a record number of interviews being scheduled. So that is a positive trend on the immigrant visa side of issuance of those green cards. Now, there may be some issues down the road with, and I think we're supposed to have it by now, but that's a delay on some countries maybe having some limitations. But we sort of already seen what the proposed list has been of countries. We don't expect that to be a huge disruption, but we'll have to see. We'll have to continue monitoring what the Department of State does with certain countries having to maybe jump more hurdles for those visa issuance. Um, that's on the immigrant side. On the non-immigrant side, I think it's going to be a similar trend. So obviously, be well prepared if you have an interview. All right, so let's do some questions that you may have here today. Um, all right, Silvana asks, I work as a professor at a university. I have an H-1B and want to apply for a green card. If I apply, can I travel to my country while the process is ongoing? All right, so first, when I give these answers, this I cannot give you legal advice over a live video today. I'm only talking generally because I don't have all the information in order to provide actual advice. So we're just talking generally here, Savannah. Generally speaking, you can travel depending on your situation. If your H-1B stamp is valid, if you have a valid 797 with enough time on it, you could travel. Sometimes it may be a good idea to also obtain a travel permit and an advance parole I-131. So there may be an ability for you to travel outside the United States with a green card application pending, but I would highly recommend that before you take any trip outside the U.S., that you consult with your attorney and make sure that everything is in order. Also, if you're going to have a green card application pending, our general recommendation right now is to wait until you get the green card, unless it's an emergency, rather than traveling. Okay. Um, because of the increased vetting, because of some of the, like I said, maybe chaos around the world with a lot of these policies. My recommendation would be, if it's not an emergency, a true emergency, wait and see if you get that green card, and you're going to be in a much better position at that point. Um, all right. Mashid, hi, and thanks for the updates. Did Trump's executive orders on immigration impact Iranian citizens? If yes, how? Well, so I mentioned it a little bit earlier. They were supposed to implement, they had asked for a 60-day study to come out by the Department of State on, on certain countries that are not, according to this administration, meeting the requirements for national security and other issues. The Department of State has delayed the issuance uh, of that final order on it. We expect it to come out at any point. So we do expect, unfortunately, on Iran, that there will be some restrictions. We don't know exactly what those would be. Um, so yes, we expect some restrictions for uh, Iranian citizens down the road, but that has been delayed at this point. So we're sort of in a holding pattern with Iran, for example, to see what impact it may have. This is mostly for folks that are outside the United States, um, that may need to get a visa, either immigrant or non-immigrant abroad. So we will see how in the coming weeks if the Department of State finalizes that list of potential countries that may have some restrictions. Um, all right, Randy, are Canadian businesses eligible for E1 treaty visa so I can open a branch office in Florida? So, Randy, E1 or E2, Canada does have treaties for E1s or E2 investor visas. We would have to see which is a better option. E1 is for trade between the two countries. There has to be substantial trade. E2 is for an investor visa. There may also be an L1 opportunity. Uh, L1 is for a company, a Canadian or other company, opening up a branch or subsidiary in the U.S. Um, so we can take a look at the options for you. Canada does have treaties for those for e visas, but also um, you would have to be obviously a citizen of Canada in order to qualify for that. But also we could look at an L1 intracompany transferee opportunity, or even an O1A, depending on what you're planning to do. Those are non-immigrant visas. EEs are non-immigrant visas. They're not green card applications. Um, but we can look at the different opportunities that you may have if you're a Canadian citizen. Um, all right. Tom, you mentioned an increase in the trend of approvals for IRS green card statuses. Is there an improved time frame for approvals of initial applications? We are seeing more adjudications, Tom. It is, and when I said trend of approvals, we've seen a trend of action. Okay, we've seen a lot of approvals. We've seen more RFEs, as I mentioned as well. So we'll have to see long term how that plays out. But we have seen a trend in trying to move cases a bit faster. Now, premium processing is interesting. I think premium processing is getting a little bit overwhelmed with the number of applicants. They are issuing a lot more RFEs at the premium processing, and they seem to be a little bit tougher on some applications. So, right now, unless it is absolutely necessary for you for some reason to do premium processing, whether it's an EB-2 NIW or an EB-1A, I would recommend against it. Um, but we've seen approval times a little bit better in the last few months. We'll have to see. The problem with trends on timing is that it takes time. um, because we may see some now, but then 6 months down the road, it either slows or increases. So it's difficult to give you a 100% of anything with immigration, but especially with processing times, I would like to see a little bit more time under the Trump administration to give you a better answer on are they going to move faster or not. Um, One of the concerns has been that Doge, led by Elon Musk, has uh, has been cutting a lot of government jobs. Right, they've been slashing the number of employees at the government level for many agencies, but not on the DHS side on immigration, especially USCIS, which handles the applications. In fact, if you go to their social media posts, you'll see we are hiring. So they seem to want to continue to hire, and they're not slashing those jobs. At least we haven't seen that at this point. So hopefully they won't do that, and adjudications will continue to move forward. Um, okay. Ronnie, hi. For dependents, how old is eligible? My son turned 21 and married full time student. May I include him? No. So aging out is an issue with any kind of green card application. Um, when your son or daughter turns 21, they are no longer eligible to be included in your application um, unless under what's called the Child Status Protection Act, the CSPA, they are protected, which can be difficult because it will depend on a formula that has to be done. And it depends on the green card category that you are in, whether they would be eligible to receive a green card or not. So the short answer to your question is if your son or daughter has already turned 21, in case your son, Ronnie, and you have not applied yet for a green card, they will not be included in your application. They would have to find an independent way to be part of or to obtain some kind of status in the U.S. It's important to keep in mind aging out because with with more visa wait times, there is a backlog on most visa categories nowadays, and that can affect the application for a dependent child or daughter. So that's why it's always important if you're thinking, let's say, if you have a 15, 16, 17-year old child, delaying is never a good idea because it can just become harder and harder. They will age out at 21 unless there's some kind of CSBA protection. But for many employment based categories, it's not going to really help them. Maybe EB-5 is one of the few, and some, depending on your nationality as well, because there are certain countries that have a more significant backlog, China and India being one of them. But EB-1As for the rest of the world, or sometimes EB-5, can be more available options to try to avoid age out issues. But those are the kind of things that we would have to discuss with you as a potential client to see what options there may be. But if your child is already 21, they're not going to be included in your application. All right. Mariana, what is the current time frame for a response on the expected path for an NIW visa? Is a work permit possible for a TD visa holder? So, on an I-140 NIW case, we're seeing, and again, average wait times, they fluctuate quite a bit because it also depends on the officer that has your case. Some officers are faster than others. We're seeing on average, uh, I would say nowadays, 15 to 20 months. It's sort of the average. It could be less, it could be more, but on average, that's sort of what we're seeing in the last, I would say, 100 days under the Trump administration of cases that have been uh, processing for some time. The Biden administration actually sort of slowed down in the last 6 months or so with adjudication. So, um, again, we're hoping that immigration will pick up the pace and we're going to see some maybe decreases. But again, it's also due to the demand. The demand for green cards has increased in the last few years. And so it's just a natural trend of a little bit longer wait times. Now, you compare that with options around the world. It is not unusual for a case to take a year or more uh, globally for permanent residency. Um, but that is sort of what we're seeing today. Now, a temporary work permit, Mariana, that will depend on whether you have filed for adjustment or not, depending on your priority date. That is a very specific question that you would need to go through. Also, because TNs and TD visas are, they don't recognize directly dual intent. You have to be careful with that. So that's something that you should sit down and discuss with your legal team in more detail. All right. Mash, do you work on just immigrant visa categories or non-immigrant? No, Mash, we work on non-immigrant cases. Uh, Again, we mostly focus on investor or professionals. We don't do family or asylum cases. Um, But we do non-immigrant on the O1A being a perfect example of what I discussed earlier. O1As are a great tool for professionals. A lot of them don't know exactly how it works, and it could be a great advantage if you want to. Instead of waiting that long, the period of time that it's taken right now for an immigrant visa, you may need to be here sooner. An O1A may be a good option, and one of the benefits of the O1A that is sometimes not understood is that. Um, the sponsorship opportunities are a lot more flexible, but also there are no caps. There's not a certain number of visas that are issued every year. It's uncapped. So unlike an H-1B where you have 65,000 plus an extra allotment for masters, there's not a lot of H-1Bs available. So there's a lottery. O1As, you're not subject to that lottery. You're not subject to those caps. So non-immigrant cases. So we do O1As, obviously, E visas, E2s, E1s, L1 visas. So we do handle non-immigrant visas as well. All right. Ken, can I apply for an EB-2 NIW, EB-1A, and O1A visas at the same time? Yes, you technically could. There are costs associated with each filing, so I'm not sure you want to do all three at the same time. Um, I would suggest if you're considering all three, to begin with an O1A, which is a fairly fast process, especially if you do premium processing. Although you don't really need to unless you're really looking for a very uh, fast process. And then you can look for the permanent solution within an IW or an EB1A. But yes, technically you could do all three. Um, I wouldn't recommend filing for a green card application while you're pursuing an O1A, just because you don't want to go through that at the consulate of what is exactly your intent of moving permanently to the United States or not. It's much cleaner if you get your O1A visa, come to the United States, and then if your intent changes down the road to stay here permanently, you can then file for a green card application. That will be the cleanest way to do that. All right. Let's see. Let's do one more question here. Stefano, generally speaking, does having a double citizenship, UK plus EU, help to get an EB-2 NIW visa? No, not necessarily, Stefano. I mean, each officer has their own way of looking at cases, right? And they're human beings, and there is some there's a lot of discretion that an officer may have on an NIW case. They're not supposed to be discriminating based on citizenship. Um, there may be some countries that could suffer certain prejudices, uh, uh, but that is not the law. Okay, now um, the on the executive order side, like I said earlier, there may be some actions that are taken either through executive order or the Department of State actions where certain countries may have certain limitations. But technically speaking, your nationality being UK or EU should not affect the decision on an NIW case. Okay. Um, all right, let's do one more. So we can get to one more question today, and I hope that it helps. Let's see. Lanson, what are the requirements for an O1A visa for someone already in the US on F1 STEM OPT? So you can, we have videos on YouTube on the specific requirements of O1A. So you can look at that, or you can also contact us and we'll do a free evaluation once. And a lot of our O1A clients are here as F1 students or OPT students. So that is sometimes a good option. But essentially, you're going to have to meet certain requirements of extraordinary ability. So if you're studying a PhD or a master's, For undergrad students, maybe graduating or on OPT, that an O1A may be harder because they don't have enough professional experience. But for if you're studying a master's or a PhD, you may have a much stronger argument. And you can see you need to meet at least three other requirements that are posted on our website for O1As. But we do free evaluations for you. So I would suggest following the link. We'll post it here on the chat so you have that link. We would want obviously a copy of your CV, and then we can take a look at that and give you our thoughts on a potential O1A application. All right. So first 100 days of the Trump administration, some good things, some things that you need to be aware of that may not be so good. Again, there's always opportunities when there's a new administration. So I hope that at least today you've learned some of the positive opportunities with some of the executive orders and some issues to be aware of if you're going to be applying for a visa down the road, or if you have a case pending with USCIS. We will continue to bring you updates as we hear them. With this administration, it could be every other day that there's updates. So we'll try to keep you updated regarding important potential issues with the Trump administration down the road. We hope that they will continue to attract folks like you, the brightest and the best from around the world, especially if some of these policies are to increase the American manufacturing and some of the other priorities that Trump has spoken about in the last few months. If you have any questions, you have the links to our website, and also if you're looking for an analysis on whether it's an EB-2 NIW, EB-1A, O1A, those types of visas, you have the links as well available to contact us. Again, no matter what you're trying to apply for down the road, make sure that it is a licensed U.S. attorney that is helping you. It doesn't have to be our firm, but someone that has experience with a particular type of visa, especially with this new administration. It has been a pleasure seeing so many of you from around the world. It is a beautiful, diverse group that we've had here today, and we will continue helping those make that dream a reality here in the U.S. It's been a pleasure, and I hope you have a blessed day.